All right. Thank you so much for joining us. My name is Melissa Kuczynski. I am co-chair of the ABA International Law Section's International Family Law Committee. We are producing this wonderful program today, a webinar on understanding Islamic child custody law. And we have three amazing speakers who one of my steering committee members, Jessica Flint, is going to introduce you to.
Welcome, everyone. So we have three wonderful speakers today. We have Byron Allen. He's a partner and head of the expatriate law team in the United Arab Emirates. He's ranked by Chambers and Partners, the Spears Family Law Index, and the Legal 500. And he's actually been shortlisted for the International Family Law Lawyer of the Year. So welcome, Byron. We also have Diana Hamadeh. She's a licensed lawyer in the United Arab Emirates. She's qualified as an expert in civil and Sharia law, including in the United States, and she specializes in family law matters. Welcome, Diana. And finally, we have William Tyler KC. He's a specialist family law silk appearing throughout England. He's appeared in the Court of Appeals and the UK Supreme Court, and he served as Deputy High Court Judge in the Family Law Division. So welcome, William. I hand this over to you, Byron.
Well, thank you so much. And it's very nice to speak to all of you. One minor correction. My name is actually Byron James, not Byron Allen. But my name's silly enough to not make it even more silly, but I just thought it'd be important to let you know that you're not talking to an imposter. Thank you very much for that introduction. And thank you so much to all of you for attending and to the American Bar Association to let us speak, because I think this is a really important topic. And we could have called this seminar Building Bridges, but I think we could have also called it Breaking Through the Pessimism of US Perceptions of the Middle East, and in particular the UAE, because certainly in my work, I come across a lot of misconceptions and misunderstandings about the law that is applied throughout the Middle East, but particularly the UAE, which is a particularly progressive country, which we'll come on to talk about in a family law context. And just to give you an idea, this is a country where alcohol is permitted, where sex outside of marriage is no longer which is no longer prohibited. There are many same-sex families and couples who live in this country. And I guarantee you that anyone who is really negative about Dubai or the UAE almost certainly hasn't been there. And if they did, they would probably change their mind. But with that very short introduction, I'm going to jump straight into some questions. And the way we're going to do it is I'm going to chair this. I'm going to ask Will and Diana questions, and I'll chip in a few times myself and ask them some other things and give some comments too. If anyone has any questions, please feel free to ask them in the chat, I guess, and I'll keep checking that. And if you, I'll try and answer them if we can. So, Diana, first of all, can you tell us, please, what does Sharia law mean? How is it applied throughout the Middle East? And importantly, how does that differ from the law that's applied in the UAE, known as the personal status law, both in in all of the 7 emirates of the UAE?
Hello, everyone, and thank you very much for this opportunity to be hosted by the ABA on such an important topic. As we all know, the Sharia is kind of still mysterious to many people. But Sharia is not a law. Sharia is mainly, at least linguistically, it is the path to water. That's what it means in Arabic. And Sharia is not a set of laws. Sharia is mainly many aspects of the religion of Islam, where there is the Quran and there is, of course, the jurisprudence, which has within it the sayings of the Prophet and much more than that, which is the fatwas and the ijtihad, which actually means that Sharia is not a set of rigid laws that are there no matter what. There is much more in Sharia in terms of progressive thinking. And that's why the schools of thought in Sharia have been, in Islam mainly, have been the ruling concept in the whole of Sharia. Now, in the UAE, Sharia is part of the law. It's not the law. We are not a Muslim state. We're not an Islamic state that applies Sharia on everything, regardless. We have laws. Some of them are derived from Sharia, are based on Sharia. One of them is the Personal Status Law of the UAE, which is 28/2005, as amended by the latest series of what we call decrees now. The latest was mainly in 2020. And these latest amendments were responsible for much of what we see now, of what Byron James, my dear friend, has mentioned in terms of the progress of the UAE that is aiming to host the world as a very friendly state and has laws that people can adapt to and country can adapt to them. Now, what do we say about our country? We say that we have laws that 28/2005, the federal law, that is the UAE of 7 Emirates law, but there is now a new law that was mainly called a civil law, and it's mainly a civil law in Abu Dhabi, but we'll speak about later during the webinar. Now, why are we talking about custody in Sharia? Because custody in Sharia is not what is commonly people, all over the world. People think of custody as a matter that 2 parents would have to share. So we share the custody of our children, a father and a mother. Now we can't typically use such a para phrase now, mainly because even mother and a father can be, of the same sex lately worldwide. But mainly what we're talking about is the typical family formula that we're used to. So there's a mother and a father and the children, and there's custody. So why does Islam, through Sharia, which is mainly what our UAE law 28/2005 has been derived from, has been based on, does separate this role? Why does it give it to a mother to a certain age and then to a father until the children can look after themselves and become independent? So this is mainly what we are talking about today. Did that answer your question, Byron? I hope so.
Yes, well, we're going to go through things. I mean, I think the reason I asked that question is because people often confuse Sharia law with the personal status law. And that's a common mistake that I see a lot. And of course, Sharia law, probably unfairly, but whatever, without making the moral judgments, comes with certain labels. And the personal status law is definitely different to it and attempts to be more progressive than it, which is the point I was trying to make. But Will, thinking about things more practically before we go back to more principled concepts, why is it, in your view, that it's seemingly mothers that always seem to remove children from the Middle East to Western countries? Do you think that they're fleeing genuine human rights concerns, or are they more emboldened by a kind of going or staying home mentality? Do you think that there's any reasoning or legal principles that you can think that explains that common occurrence?
Maybe the question should be, is there a legitimate reason, concern for these mothers?
Well, Will, what do you think about it, Will?
Well,
sorry, is that for me, Byron?
Yeah, Will. Sorry, Diana. Sorry. Will, what do you think about that?
Okay, so in Dubai, as everybody knows, or in the Emirates generally, there's a very large expatriate community, and English workers go out there an awful lot, often with families or have families. Problems often occur, and when they do, I often pick up the pieces from the English end, and I know that Byron picks up the pieces from the UAE end. So one cohort of litigants that we're talking about are the expatriates who want their litigation to take place in their original country, from my point of view, Britain, but for those attending, no doubt, the US. A second cohort of potential litigants are those who are perhaps native to the Emirates or that part of the world, but who want to have, for other reasons, their family disputes dealt with, in our case in England. Diana can perhaps help with whether this is right, but certainly there are a number of factors that often arise which underpin the original rationale, for example, for the mother leaving the Emirates with their children. One of the issues, it may be a relatively small part of UAE law, but which always causes problems, is the seeming ease with which somebody can obtain a travel ban from the Emirati courts in relation to their children. And whether it's perception or not, it is certainly felt that it's far easier for a father to do that than for a mother to do that. And it's certainly felt here that it's quite difficult for the mother to overturn a travel ban. So that the fear is that a mother will effectively be stranded in the Emirates for as long as the father of the children wants her to be stranded, because while she could leave, she wouldn't leave without her children. Because of the seeming ease with which the ban can be obtained, the only way to beat it is to leave the country effectively in secrecy. In doing so, committing, I'm fairly sure, a criminal offence in or under Emirati law, and so putting herself as a fugitive from Emirati justice. So before the case even starts in England, or the day it starts, when the plane lands from the Emirates, the mother can say, well, look, I had to do this. I had to abduct the child effectively because otherwise I could have been kept here forever. Oh, and by the way, in doing so, I've committed an offence for which he could have me imprisoned. Therefore, I can't go back. So that's certainly, from our perspective, one of the reasons why it's often mothers, and one of the reasons why they come here. The other principal reason, and again, Diana can help us with the extent to which this is true, is that while the personal status law is certainly not wholly Sharia and not to be confused with Sharia, the Western understanding is that the principles in relation to custodianship and guardianship are pretty concrete, and that a mother will be custodian of a boy until X age and girl until Y age, whereupon custodianship passes to the father. And there's no sliding scale in relation to that. There's no, well, you can have 3 days custody a week, I'll have 4 days, or you have every other weekend. It's pretty much all or nothing. And certainly from what we've seen in English cases, the only way a father can overturn that presumption is by effectively proving the mother to be unfit or un-Islamic or something similar, which, rather than winning him a bit more custody, simply flips the residence of the children completely in his favor and disenfranchises her. And so if the latter's true, then that would, I suppose, be proper human rights reasons. If the former's true, the travel ban, I think that probably would as well. But I wonder if it'd be helpful to find out if those preconceptions are true generally, and then secondly, how they're affected by the more recent developments in the Emirati judicial system.
Yeah, well, Diana, so let's just, for our audience, let's just explain some things, some terms of arts there. So a travel ban is a remedy that's available from the personal status court that prevents children traveling, not a mother. But obviously, a mother might not want to leave her children behind. So just to be precise about that. And you can have a travel ban temporarily lifted, but usually, Diana, you would need the passport of somebody as a guarantor, and not always easy to find somebody who gives their passport to a Dubai court as you're leaving the country and maybe coming back or maybe not, with the consequences left behind. So, Diana, let's deal with this head on. Is the travel ban one of the worst aspects of personal status law when it comes to things like women's rights and fairness overall?
Well, I have to say that the travel ban has been, to many, many parents, whether a mother or a father, a lifesaver. The idea in the UAE that everyone from every part of the world lives in the UAE. So I'll just give you an example. I had a case where the mother was a Filipina, the father was Australian. The father took the children to Australia. The mother cannot get a visa to Australia. The father will not get her a visa. She could never see her children again. She does not have the ability to go and fight in Australia to see her children or even get to be with them. This is one of the examples I'm going to give you. I can't tell you how many people of many nationalities live in the UAE. So the UAE, because we're not signatories to the Hague Convention, for a reason that is, I'm not going to say beyond us, beyond the UAE, but the reason was always that men of the UAE, nationals of the UAE, marry sometimes foreign women, women from other countries. And the fact that this woman would be able to go to her home and claim the custody of her children there based on the Hague Convention, and the UAE would have to make a compromise because of the Hague Convention to say that the children can stay with the mother and then they can come to see the father on vacations, on weekends or whatever, was not something that the UAE accepted. The idea was that they're not protecting expats, or they're not trying to prevent expats from being with their families or not leaving the country. They're trying to protect their own nationals. And that was the idea behind refusing to be signatories to the convention. And by the way, this is not only the UAE, it's most of the Arab world. Of the Arab world, I know one country that has signed the Hague Convention as a signatory, it's Morocco. And in Morocco, things are completely different from the way things are done in terms of personal status law all over the Arab world, the other part of the Arab world. So is it bad? Yes, it is terrible. I've seen children who had not left the UAE since they were children. Honestly, I see a child who's 15 and 16 and they tell me that, Diana, I've never been anywhere in the world because my mother has a travel ban and my father has a travel ban. You know, most of the children have travel bans from both parents because everyone is scared that the child would just be taken by the other parent to a country that they would not have access to. The only victim is a child who has suffered for years being stranded in the UAE. Now, is the UAE gonna change this law? I don't see it changing. I'm hoping that the UAE would actually sign the Hague Convention. Sorry, Ryan.
Well, I was going to talk about the Hague Convention in due course because that would be a very interesting thing for them to do. But when you say that, will they change it, you're not sure, of course, in Abu Dhabi, they have recognized that. So one of the things that's very, not difficult, but just to help people understand, this is a country where the expatriates outnumber the locals by a huge factor. And it is a genuinely very cosmopolitan place. A bit like a capital city like London or like a New York, but where the local population is much, much smaller. And so we have this unusual situation where the law is set by the few and intended for the few, but the many access the law and find it culturally incompatible with a lot of their conceptions about things like family life. And so in Abu Dhabi, they have now acknowledged that that is a problem, and they have created something called the non-Muslim family court or the civil court of Abu Dhabi. And of course, it's fair to say, isn't it, Diana, that it's very embryonic. So we'll wait to see how they interpret their law, but it is meant to be a more culturally appropriate forum for expatriates living in the Emirates of Abu Dhabi. And it will be interesting to see how travel bans are dealt with there. Now, we'll come on to talk about that court shortly, but just on the subject of travel bans, I don't know, Diana, if you've had an experience yet of how the non-Muslim family court deals with travel bans, whether it's the same as the Sharia court. Sorry, I just made a mistake there. Personal status court. I did the thing that I said you shouldn't do. I'll be removed from the chat.
The name of the court is still not really something that we're used to. But
Yeah.
I haven't seen it yet, but I presume that you know that the travel ban is not part of this personal status law. We don't have anything in the personal status law, 28 of 2005, that says the travel ban anywhere. The travel ban is mainly found in the immigration law, and the employment law usually, where there is a travel ban that, mainly stops people from leaving the country if they have committed an offense, or they have not really paid money. Something very similar to the arrest warrant, but a travel ban. But the travel ban used by the Personal Status Court has been created by the Personal Status Court to avoid people coming screaming like crazy mad people at the court saying, my child has been taken to a country because you let it happen. So these judges, when I sit with them and I do my screaming, like, Your Honor, my client has been under a travel ban, her child she cannot leave. And the judge says, well, Diana, I had to do this. Do you know the cases that have been slammed right and left? I understand. They're doing it out of concern. They don't want the UAE to be seen as the place where people, fly away with children from partners that can't reach their children. And they have no, I would say to an English woman, if she's so devastated, and and a French man, and I'd say, go back home, use the Hague Convention. You can always see your children. But I can't say that to a man or a woman that are forbidden to go to a state without a visa. And they happen to be married in this country, and they happen to have children in this country. So this is part of how we grew up with a law and with the community that Byron just described. Honestly, UAE nationals in this country are less than 10% of the population. Everyone else is an expat.
Well, one thing to acknowledge straight away when we're talking about these issues is jurisdiction. And actually, children can live in the UAE and be subject to multiple jurisdictions. And that is one way of dealing with the travel ban. But let's start from first principles and just think of it as international children lawyers for a moment. Most jurisdictional tests are based on habitual residence. Where does a child live? Where's their centre of interest? I.e., where do they go to school? Where do their parents live? Where do their parents work, etc. And so that is normally what decides whether a court has a jurisdiction over the welfare of a child. But on what basis can other tests apply to children who are living within the UAE?
Well, you're right. Most Western countries have habitual residence as the founding principle of child jurisdiction. And of course, that's enshrined in the Hague Convention, the 1996 Hague Convention. America and Canada, not being signatories, have a similar test, but not quite the same. So I think it's the home state test under is it UCCJEA or whatever the acronym is, which applies both to individual American states, but also as between America and other countries. And even within countries with the same test, you can have two countries both claiming jurisdiction. So it's perfectly possible for both England and France to say, well, we have jurisdiction under the Hague Convention because we think the child is habitually resident here. It perhaps wouldn't happen very often as between England and France, but I've just had a most unfortunate case involving my client who thought the children lived here in England and the mother who thought they lived in the Russian Federation. And the Russian Federation, interestingly, although it's been expelled from the Human Rights Conference, remains a signatory to the 1996 Convention, and put conservatively, perhaps applies it rather differently to certain other countries. And in that case, my client lost out to Russia, who was first to have proceedings and to conclude that the children were habitually resident there. And he says, I can't go to Russia, not least because since the invasion of Ukraine, my life would be in jeopardy if I did go. So first of all, there can be jurisdiction in more than one country because both countries applying the same test apply it differently or find in favour of themselves. Secondly, most countries have some other residual bases of jurisdiction. So in England, for example, there's an unusual basis of jurisdiction based on matrimonial proceedings. So if the Hague Convention doesn't apply, even if the child isn't habitually resident in this country, if there have been matrimonial proceedings, so a divorce or judicial separation in this country, then any children dispute, which is related to, however that's defined, the matrimonial proceedings, will find jurisdiction remaining in England. So certainly, Byron, you and I have had a number of cases involving English expats living in the Emirates, where undoubtedly the children are habitually resident in Dubai or whichever Emirati state it is, but where for other reasons beyond the scope of this talk, the divorce has taken place in England. And in those circumstances, if you can establish that the children dispute is related to the divorce, which normally it will be if it's close enough in time, then the English court has jurisdiction. We also have an anachronistic jurisdiction based on nationality. Whilst lots of countries have a nationality-based jurisdiction, it's probably only England that has that on the basis that our monarch is technically the parent of every child in the country, and which calls it the parens patriae jurisdiction because of now His Majesty's status. And because of that status, every citizen owes the monarch a duty of loyalty, and because of that, the monarch owes them a duty of protection. So if a child's in danger, an English child, a British national, anywhere in the world, then that jurisdiction can be claimed, even though the child is habitually resident somewhere else. So, for example, British national children have been helped when they are at risk of female genital mutilation or forced marriage in India or Pakistan or wherever in the world it is. We in England don't have a separate head of jurisdiction based on forum necessitatis. My reading of the UCC JEA is that America does have that, in the sense that if the legal system of the child's home state is found to offend against US human rights principles, and if there is nowhere else which in the world which can exercise jurisdiction for the child, then the US will have jurisdiction in relation to that child. So all countries, most countries, have their own sometimes anachronistic secondary or residual bases of jurisdiction, which can be hugely helpful, but of course which can give rise then to the standard dispute of which country should hear the case. So far as England and Dubai is concerned, it's those cases when the English lawyers will probably, by seeking to criticize Dubai principles or Emirati principles of family justice, claim that the case has to proceed here. We can talk about that in due course. One of the issues for the judge to decide when contemplating whether or not the case should proceed here is if the child remains at the time of the case in the Emirates, then how would any order be enforceable? And if they're English citizens, if there's property in England, if they can't afford to put themselves essentially as fugitives from England or from European justice, then it may be enforceable that way. But a question we'll come on to post Lencore and reciprocal enforcement is whether there's increased scope in the future for an English order in relation to a child living in the Emirates being directly enforced through the courts of the Emirates.
Well, let's deal with that straight away. So what Will's getting at there is one strategy that we have used as international lawyers dealing with the UAE is to obtain orders in a home country using one of those other grounds of jurisdiction to then apply what we would call in personam pressure, and by that I mean orders against the person rather than say in rem against the thing, to the individual for them to comply with the order in their home country. And there are certain instances where that is particularly effective. So if the other side is a lawyer, for example, and an officer of the court, they have to comply with the orders that the court makes. or as Will says, if they own property in their home country, or indeed if they're willing to travel to any country around the world that that country has a relationship with. And so in personam enforcement is one way of applying pressure. So for example, in our travel ban situation, you could get an order from a Western court against the person to take all necessary steps to discharge the travel ban. And that doesn't require reciprocal enforcement in the UAE. It is an order against that person. And then you take sanctions on that person if they don't do the thing that they've been ordered to do. But Diana, what is the attitude of personal status judges, let's say in Dubai, particularly, but in the UAE, to orders made in other countries over children who are living in the UAE? Are there circumstances, for example, where a UAE judge would say, well, look, I can see that this American child is subject to proceedings in America. Therefore, I am not going to investigate this matter. I'm going to defer to the American court. Or do they take the attitude that they essentially should make orders over any child who's present in their country?
So I would have to say from experience that even before what we had just witnessed a month ago, that the UAE and England, the English high courts have come to what looks like a reciprocal agreement for enforcement of foreign judgments. I can remember like 3-4 years ago, I had a case where a child, an English child, was visiting his father in Dubai on Christmas upon an agreement that was entered into a judgment in the English high courts. And there was an order by the judge that as soon as the vacation is over, the child should be returned to England. And the father of the child decided to abduct the child and run away from Dubai with his new person. The mother from England was calling, trying to get to speak to the child. She never got through. Then I was asked by the lawyers in England to help get the UAE to return the child to the mother. The father has obviously used what we call in Dubai, trying to say that she shouldn't have custody, that the boy should stay with him. He used the courts in the Dubai courts, But I was more than pleased to see a judge in Dubai at that point where we didn't really have any reciprocal agreements, any respect or enforcement of a foreign judgment between England and Dubai, that the judge in Dubai decided that since, and exactly that's what William referred to, that since this child, as per the judgment of the English courts, is under the protection of the monarchy of England, so the child belongs to England in a way that, it's a subject of England and has all the protection. The judge was quite impressed with the way the judgment was read. And he said he actually got an arrest warrant against the father in Dubai. We got the child back. We got his mother to Dubai. We put the child on a plane back to Dubai. And that was almost 4 years ago. And Byron knows the lawyers on the other side that were actually representing the father. And that was the first case that the Dubai courts returned the child to England because the child came with a court order from England that the child should be returned to a mother.
The moral of that story being, if you need help with getting a child back from Dubai, give Diana Hamad a call immediately.
I've done that plenty of times. And I am
what's interesting about that story is, of course, it gives a real insight into how the personal status court works. It's a civil code. There's no binding precedent. So we don't have common law cases. So you can't say, well, what does, so when a client comes and says, well, what does the Dubai judge do? You can't refer them to common law precedent to bind them as to what to do in that situation. Actually, they have a lot more freedom, I find, to interpret the civil code in ways that they think is the correct way to give justice to the situation.
Which I would call
and therefore, Diana, because of that, that means that they're always open to those kinds of arguments, right? Where you can say to them, because I've actually had this in divorce cases as well, where we said, there's already a petition in England or wherever, will you agree for this non-Muslim family to be governed by a law that is more culturally appropriate to them. And the Dubai judges said, sure, that's fine, doesn't bother us, no problem.
Yes.
Go ahead. And it's very interesting to me that they're actually quite open to those things.
So the flexibility that you see in our courts, I would say quite wide. So there is a flexibility. So from the discretion of a judge to, I may differ with you here, Byron, on the precedents, because I do use precedents and they do exist. And in a way, although we do not really take them by heart, like the English system, the Anglo-Saxon system, where a precedent is a precedent, but we do actually ask our judges to follow precedents, and they do. So there is flexibility. There is a lot of custody matters that can be dealt with in a better way, but still, we're talking about a law that binds the courts, the judges, with whatever is in the law, unless they can get out of it with their own discretion.
And one thing just to touch on quickly, which both Will and Diana have mentioned, but just to highlight for everybody, we're not going to go into any great detail actually, just because this isn't to talk to English lawyers, but there was a decision in England where they upheld a Dubai judgment. And then because England upheld a Dubai judgment, there is a part of the civil code that gets triggered when that happens. And it means that Dubai then, by return, will provide reciprocal enforcement to English judgments. And so that was a case called Lencor. And the Ministry of Justice circulated a letter around all the courts and said, we now reciprocally enforce English judgments and they enforce ours, which, Diana, not to go into great detail because obviously it's to an American audience, but it's an interesting international step because and it shows an interesting precedent for American judges, right? If an American judge wanted to uphold a Dubai judgment, for example, then that might have some building bridges consequences for future enforcement between those two countries.
Well, for the sake of just being with, I guess, among the 95 participants that we have, I don't know really how many American lawyers and judges there are, but my experience with the American courts has been quite, varied. Like I appeared before Florida court once as an expert. I appeared before New York many times as an expert. But the one law that I applied in Dubai courts, and that was an American law, was a Louisiana law. Why? Because Louisiana has a civil code like ours. So actually there was a big book of a French code that was, I think Louisiana was a colony of the French. That's geographically, historically, that's the case. But this is what I could actually come with to a Dubai judge and say, I have a client from Louisiana. She was married in Louisiana, and I want you to apply the law of Louisiana. Can I do that with other laws in the US? I couldn't. Honestly, I have to admit that the English law and the American laws of the states of the US are not as, as applicable as our laws in the Middle East, in France, in Spain, because we have code, we have a book where we have provisions, articles, while the English law and the American states laws are mainly acts and precedents. So the judge would never be able to have them compiled in one. And we do apply in our courts the law of the marriage. So this is where we have actually got out of application of only our law to divorces. And now we are applying foreign laws to divorce in Dubai courts, in Abu Dhabi courts, the normal courts, the federal courts.
I mean, there are still practical problems, aren't there, Diana? Because so someone has actually asked a question about, did the law change in 2020 to the personal status of law of Dubai just apply to divorce or child foreign law, applicable law? And of course, that change just applied to divorce law. And so that was the location of your marriage would set the country law that would be applied on your divorce. But there are practical problems that exist because the Dubai Personal Status Court only uses Arabic as an official language, whereas Abu Dhabi uses English and Arabic. And there are, it's fair to say, translation issues that can arise between Arabic and English, where one word in Arabic can mean 10 different things in English and vice versa, looking for issues, but also the practical problem, Diana, that you said about the amount of information that you would need to translate, which would be problematic, and then interpret. I mean, I am aware of a case, which I'm sure you are, Diana, but you may have been involved in it, where they applied Belgian law to a shared care order a few years ago. So they also do apply foreign law in children cases as well, but only if it's, you know, very easy to apply and based on a code usually. Well, just dealing back with Dubai law before we start talking about Abu Dhabi, to what extent do you find that a welfare principle exists under the personal status law of the UAE? And in your experience, how does a more Western concept of the welfare principle compare to that which you've seen applied in the UAE in your cases?
This is the biggest. Sorry.
Go on.
Yeah.
This is the biggest hurdle, I think, to there being any meaningful reciprocity between the two systems, simply because the applicable statute in English law, the Children Act, has at section 1, subsection 1, the exhortation that when deciding anything about a child, the child's welfare has to be the court's paramount consideration. And that is then universally applied as meaning that the individual child must have his or her circumstances properly researched and investigated before coming up with a truly bespoke solution for that child. And because, for example, something as simple as residence and contact, there's a complete sliding scale between completely with one parent, completely with the other, anything in the middle, without any particular paradigms that are applied in this case or that case. It means that every case has to be decided by that investigation. My experience of Emirati cases, and this isn't a qualitative judgment, but one I think of a fact, is that there tend to be relatively fewer permutations. And so the first is that I referenced earlier, which I think is right, that the standard solution post-separation is that the mother becomes the custodian of the child until the child reaches effectively the age of puberty, which is differentiated for boys and girls. And if there is a dispute, the father then has very little contact with that child. So that might give the lie to the notion that Emirati law is universally focused in favor of the man. But it also creates the difficulty that it looks as though, because there are relatively fewer permutations, and because in order to dispel one, you have to prove something awful about the parent, and then the opposite applies. It means that certainly to Western eyes, it looks as though the welfare principle is applied with a pretty broad brush. Is this child in mortal danger, or spiritual danger, or whatever the test may be? And that's certainly the argument that I would always use if trying to persuade an English court to exercise jurisdiction, coupled with the fact that in an English decision about a child, any significant decision, that child's voice will be inputted into the decision. So if they're old enough to express an authentic view about what's happening to them, that view will be obtained. It may not necessarily be acted on for all the obvious reasons. But so far as I've seen, and I'll be told if I'm wrong, that principle doesn't apply, at least with the same regularity, in the Emirati courts. And that then provides this huge difference between the systems of the Judeo-Christian courts and the Islamic courts, which makes it quite difficult, I think, for each to understand how and why the other's doing what they're doing.
Well, Diana, let's put that to you. So how can a true welfare principle be said to exist when there are such rigid gender-defined roles for parents?
I may say something quite controversial now, but why? Okay.
Oh no! Stop recording.
Why do we in the Middle East under Sharia give the mother the custody and the father visitations that are quite little and burden the father, even if the mother is wealthy, with every expense of the home, of the child, of a housemaid if she's been served in her parents' home. It's a cultural thing. So imagine you're talking about a Muslim man who has 4 wives. Every wife has a set of 6 to 8 children, sometimes 10. This man would have to see his children. Are you serious? Shared custody? If one of those wives decides to leave, why would the father wants to be with 10 children half time? No, he doesn't want that. So this law was created for these people. The mother is a custodian. She looks after her children.
For and by those people.
For and by those people. Okay.
Yeah.
So this is the idea. An expat man. I mean, I remember once I appeared before a judge in Dubai court and I said, Your Honor, my client is a Dutch, French, I can't remember, man, who has been so involved in his child's birth and life. And since he was a child, he changed his nappies. He gave him milk because the mother was like a full-time employee and like she had a full-time job. And the judge said, Oh, is this man? I said, yes. Oh, okay. Your client is not the typical man that I would actually call a man. I said, Your Honor, you're not supposed to say that about my client. He's a man, but he's a man who's involved in his child's life. And he said, yes, but I'm not here to give him more time. Or my law says once a week, 2 hours. I said he would die. He said he'd rather see a psychiatrist for that, or like, see his family for that. Or imagine, this is the idea. And these expat people expect in my courts, not my courts, our courts, to see something, to find something different. I mean, the judge wouldn't give a father an overnight, a sleepover, unless the child is already above 9 or 10 or 11 years old. And he wants to make sure that this father would not have men in his house alone. The welfare of a child is protected. I mean, to me, this is the best protection you can give a child. And the best interest of a child is actually where the judge's discretion is all about. The law says specifically, it states the child would stay with a mother until the age of 11 if he's a boy, and until the age of 13 if she's a girl. I mean, who on earth wants to take children from their mothers at this age just because it's in the law? Actually, that's what Sharia says. But for God's sake, who wants to take a child from a mother?
But the irony is the social conservative nature that you're referring to often means that they say children should stay with their mothers, in my experience. And they don't supply that rule. Yeah.
So mainly the judge would actually, within his discretion, we call it in Arabic tamdeed hadana, which actually he, because all judges and all our courts, personal status in all the Arab world are men. There are no women.
Well, this is what I was literally about to ask you, Diana, because of course, one of the interesting things for me is you're talking about these standards, shall we say, these cultural and moral standards being applied, but who are they being applied by? They're being applied by men all over, would you say, the age of 55, over the age of 50?
No. We have young Emirati judges now.
Okay, fine. Now we do, but I bet they apply things slightly differently. Yeah, I think as well, one of the great things about the UAE is the willingness to embrace modernity and change. I think that's an attitude that over time, as if the demeanor and culture and diversity of the judges can change, I think that's the sort of thing that would also change in due course.
Could I ask this? Because this bears on that. A lot of what you described, Diana, is effectively just the clash of two very, very different cultures. And that isn't to say one is better in any way than the other, but as cultures, they have very different ways of expecting people to behave and of ordering family and other life. And of course, Dubai or the Emirates is an odd place because it's Arabic and Muslim, but as you've said, it's populated by a vast number of non-Arabic or non-Muslim people. The Abu Dhabi non-Muslim family court, number one, by whom will justice be dispensed in that court? Is it the same sort of cohort of judges or different? And number two, do you have any feel yet for how differently standards will be applied, and whether there'll be a more European or a more Western approach to things like gender roles in childcare?
Well, Will has stolen my my link there because I was about to link into that, but he did it far more eloquently than I could do. I mean, just explain to everyone really, really quickly. There are 7 Emirates in the UAE. One of them is Dubai. One of them is Abu Dhabi. Abu Dhabi has, and they all have, like in the US with federal law across states, they all have their own laws, but they also have, then there's the law of the UAE that applies across the whole country. Personal status law is a matter for each Emirates. And so they all have their own personal status law. And in Abu Dhabi, in January this year, they did something completely unique and wild. They set up a completely new court, brand new jurisdiction to deal with non-Muslims and their personal status issues. So divorce, custody, and some other things. And so it is a brand new jurisdiction that has a civil code, which you, if anyone wants, email me and I can send you the law, which I believe Diana is just subject to a new translation into English. I think, Diana, it's fair to say that they are still in the process of appointing judges to sit in that court. They have some, but they want more. They want to have a wide, diverse group of people who are judges applying the law, who are non-Muslim. And the amazing thing from a children perspective is, contrary to everything that Diana has just said about what happens in Dubai, the starting point in Abu Dhabi on separation is shared custody. That's better than even England and most Western countries, in my book. So you start with shared custody. Now, how that's interpreted, Diana, you can tell us a bit more about what then happens thereafter.
So let me, just to be fair to the courts in our country, first of all, we do apply foreign laws. Remember, the same judges that do apply our law are the judges who apply foreign laws. And they do a great job at reading the law and applying it. So mainly the judge is just applying a law. They're not really getting the law out of them. They use their discretion, and I have to give them so much credit for that, in the best way possible to protect a child. Usually that is their main concern. And now, before I talk about Abu Dhabi, just let me tell you about the new custody law that was created by Dubai. It's custody, they called it a custody committee. The idea was here by the custody committee that the child place, whether it's a home that was provided by a father or a mother, just to examine the welfare of the child within the place that they're living in. The one comment I had, and the one issue that I had with this custody committee, is that the child will not be asked. And honestly, I have to say, many lawyers just thought that this was the best way to do it. And these lawyers are not only from the UAE, but from many parts of the world, saying that the children can be manipulated. And the children should never be asked, who do they want to be with? The best interest of a child is to be in a place that provides them the best services, the best place to school, friends, family, and that's the idea. Now, about Abu Dhabi. Abu Dhabi courts, the way it is set up and the law that is applied there is unique. It's not something we're used to. And it's still work in progress. And I know for a fact that the judges are capable of applying a law. All they have to do is just read it. This is the idea of a civil code. You are trained to read a book that has articles in it. Of course, you're trained in a jurisprudence in a way where you have that background of what you are, you've studied at university, what you've been trained in the court. Our courts now have many young Emirati judges. They all speak English. They have been to schools here in the UAE. Remember, we live in a country that is so cosmopolitan that most of these judges maybe went to private schools. They had friends from many parts of the world. So really what I see now is that the courts are gonna do much better. Like, I've been a lawyer for 20 years. My father was one of the first lawyers in the UAE. He was one of the 5 first lawyers in 1971 when the courts actually were set up in the country. And I still remember, God bless his soul, he passed away 20 years ago or so. He said to the legislator in the UAE, please do not have a law that you will base on Sharia. You either give me a Sharia court that is where the fatwas can progress, where things can be done, where the judges understand us and we understand them, or have a law that you would call a civil law, not a word of Sharia in it. Do not complicate. And my father had 4 daughters. He was afraid that these young girls in his house, his daughters, are gonna be one day subject to a court, a law that may undermine them or not be fair to them, because he believed from day one that having Sharia and the civil law integrated in one piece of a hybrid law was the biggest mistake the UAE ever did. And some of the judges told me, when I became a lawyer, they told me, they said, some of them would just make it like a joke, and they say, well, Diana, if your father lived longer, you wouldn't have this law, you know that. And that was always the comment I got.
Well, how proud your father would be of you now, Diana, if he could see. But I think, look, we'll have to bring this to a close because Melissa is now looking at me with a look, which I think means stop talking. So if I'm reading your body language correctly. But look, just one sentence of summary. I think, as you can probably tell, there is so much that one could say, and this is just about child law. There's also so much to say about divorce law and various other things as well. There are many misconceptions about this country and this area of the world, and those are coloured by a variety of nefarious things and biases and principles and whatever else. The best thing you can ever do when you're looking to get advice from someone about this country is ask someone who is here and who goes to the courts and who works in the system every day. And that is my strong suggestion to you. Thank you so much for listening, and thank you for all of your questions. I tried subtly to weave them in to some of the things we were doing, but obviously we ran out of time. Thank you all very much indeed. Thank you, Diana. Thank you, Will. And thank you, Melissa, and everyone who's been listening. Really appreciate it.
Thank you. It was so great having all of you, and I'm sure there will be additional follow-up questions. For those of you who are here, we'll make this recording available, and so we encourage you to reach out to our speakers as the need arises. Thank you so much for being here.
Thank you.
Thank you.